Please stand by. We're about to begin. Good day and welcome to the Bilzing-Sumberg Homebuilder Series webinar, Fiduciary Duties and Auditor Liability webcast. Today's conference is being recorded, and at this time I'd like to turn the presentation over to Mr. Phil Stein. Please go ahead.
Hi, this is Phil Stein. I'm a litigation partner at Bilzing-Sumberg, and I'm going to be presenting a webinar today on a couple of topics: fiduciary duties and auditor liability. Just a brief moment giving you some background on these topics and why we're addressing them. We do try in the course of our work for our clients to keep asking, in addition to the work we're doing, what are the other topics that are of real interest to you, the things that are concerning you and your business. And a couple things that we've been hearing a lot about in recent months from a variety of clients have been just general concerns about making sure that everybody's well aware of what their fiduciary duties are, the officers and directors of their companies, what committees of boards of directors need to do. And the other topic that we've heard a lot about is, what about the external auditors for our company? Under what circumstances might they have breached duties to us, and might we have a claim against them? So we wanted to address both fiduciary duties and auditor liability in this webinar. I'll tell you at the outset that because we've got a lot of people in the audience who have a wide variety of backgrounds and a wide variety of levels of exposure to legal issues, I'm going to kind of move back and forth from some very basic points on fiduciary duties and auditor liability to things that are a little more nuanced and a little more detailed. I hope the basic stuff won't be too basic for you. And certainly if you have questions when this is over, please contact me offline by email or by phone, and let's go over things in more detail. So let's start off with talking about the fiduciary duties of corporate officers and directors. I think people do have a general sense, generally, when they're in an officer or director position or advising people in those positions, about what fiduciary duties generally are. But I don't know if people have as much of a handle as they'd like on a lot of the specific applications of fiduciary duties under the law. And certainly it's difficult to keep track of state-by-state requirements, although I think we're going to find as we go through this that there is a lot of similarity from state to state in terms of what fiduciary duties are as recognized by those states. As a general matter, a person owes a fiduciary duty generally only when their relationship is one of those classic relationships that require kind of an additional layer of trust. Attorney-client is a relationship that is generally perceived as involving fiduciary duties. In the context of corporations and other businesses, some of the key fiduciary relationships besides attorney-client are officer or director fiduciary duties to shareholders in the company, the duties that agents of a corporation owe to their principal, and the duties that trustees, to the extent that they become involved in the work of a business, owe to their beneficiaries. In each of those capacities, key players in companies are going to have a heightened level of duty, a heightened level of responsibility to the people they work with. And by the way, courts in recent years have not only continue to recognize those fiduciary duties and those relationships, but seem to be expanding their sense of what constitutes a fiduciary duty, such that in at least some circumstances, lenders have been deemed to have a fiduciary duty to borrowers, and there are other examples of kind of a broadening of a perception of what constitutes a fiduciary duty. The biggest fiduciary duty, the most basic one, is the duty of loyalty. That obligates a corporate fiduciary to put the interests of the beneficiary, or in this instance the company and its shareholders, first, ahead of the fiduciary's self-interest, and really to refrain from exploiting opportunities for personal gain if they are things that would be to the detriment of the company or that should be for the benefit of the company's collective gain as opposed to the officer or director's individual gain. So it's putting the interests of the company and its shareholders first ahead of a fiduciary's self-interest. Some of the key prohibitions involved in the duty of loyalty are prohibitions against self-dealing, against having conflicts of interest with your company, and of course there's a duty to disclose material facts so that if there is any possible appearance of impropriety or appearance of a conflict, at least that's been brought up, that's been adequately and accurately disclosed to the people who need to know, and that would be the people who are supposed to benefit from your fiduciary duty. Related to the duty of loyalty, but separate from it, is the duty of care. Corporate officers and directors, I'm saying corporations, but of course this applies to other kinds of businesses as well, the key officers, directors, or managers of a company must carry out their responsibilities in an informed and considered manner. We'll talk a little bit later about what exactly that means. Part of what that means is that they must act as what, quote, an ordinary prudent person, unquote, would do in terms of managing the business's affairs. If the fiduciary has special skills and has been employed really to use those special skills, to apply those special skills, then the fiduciary must make use of them. So in that instance, a fiduciary can't say, well, I'm doing what an ordinary prudent person would do because, this particular officer, such as a chief financial officer, for example, has been retained on the basis of that person's special skills, chief financial officer, chief legal officer, and is being employed to use those special skills and must do more than just an ordinary prudent person would do. Often one of the things that is cited in terms of saying that there is not a breach of fiduciary duty is that a business transaction was arm's length and that therefore everything was above board, nobody did anything improper, nothing was done really to the detriment of the company or done in a secretive way. Generally speaking, it is true that arm's length business transactions do not create a fiduciary duty. But it's also true that what would otherwise be considered an arm's length business transaction can be converted into something different, can be converted into something that does impose a fiduciary duty. If, for example, a party takes on certain additional responsibilities that are beyond those that are required to complete the transaction. Right. So, for example, fiduciary relationship and duty may arise from what would normally be an arm's length business transaction when one party takes on responsibilities not required by the transaction, thereby leading the other party to, for example, reasonably believe that that first party is acting on behalf of the other party's interests. Let me give you a case example. There was a case involving First National Bank and Trust Company of the Treasure Coast in appellate court in Florida, involving the buyers of a new home who sued a bank that had provided them with a construction loan for breach of fiduciary duty after the builder failed to correct various defects in the home. Before their purchase, the buyers viewed a model home, which also served as the builder's sales office, in which the bank's representative offered construction loans to prospective buyers. The buyers met with the bank's representative, who told them that the bank had an excellent relationship with the builder and that the builder was a quality company. Shortly thereafter, the buyers entered into a contract with the builder and a construction loan agreement with the bank. But construction didn't go smoothly, and there were numerous delays. When the buyers had difficulty getting responses from the builder, they contacted the bank from time to time and asked the bank representative they'd been dealing with to intercede with the builder. And the bank did intercede, but with varying degrees of success. The day before closing, the buyers informed the bank of numerous defects in the house and asked to freeze the final draw on the construction loan because they were still having difficulties with the builder. The buyers also asked the bank whether they needed an attorney at the closing. The bank assured them that it was unnecessary and told them that everything would be dealt with appropriately at the closing. Well, things didn't go right at the closing, and the bank never obtained an affidavit from the builder. Defects were never fixed. The buyers brought a suit against the bank and the builder. And the jury found in that case that the bank had voluntarily taken on extra services for the buyers and knew or had reason to know that they were relying on the bank to counsel them and to inform them, and thus a fiduciary duty had been created where one otherwise typically wouldn't have existed. The fact that the bank, in other words, got into a position where it was really acting on behalf of the buyers and counseling the buyers created what might not otherwise have been a fiduciary relationship, converted that into what was a fiduciary relationship, and the jury awarded damages equaling the cost of the repair for the poor workmanship of the builder. And the appellate court upheld that. So that's just one example of fiduciary duties being created by the independent kind of voluntary acts of someone who takes on a greater role than they might otherwise have had. Everything I've said so far applies to officers, directors, and in some companies, the key managers. But generally there's a special focus on directors or managers in an LLC context in terms of what their fiduciary duties are, and they tend to be, certainly not the exclusive targets of breach of fiduciary duty suits, but frequent targets of such suits. And there are some trends in fiduciary case law that I wanted to call to your attention. Breach of fiduciary duty cases have increasingly focused on the inaction of directors, lack of oversight by the directors, and lack of independence on their parts. And focusing for a second on the first two concepts that I mentioned, inaction and lack of oversight, it often is the case, believe it or not, that directors or even top officers of a company who have been sued or threatened with suit for breaches of fiduciary duty will say that everything that they did was essentially a reasoned business decision, including, for example, not looking at something, not convening meetings of the board or meetings with top officers to go over things. And that is really kind of an overreach and an improper application of fiduciary duty law. It's not a decision to not meet at all. It's not a decision not to get together with somebody or to essentially abdicate your responsibilities on something of real importance to the company. So inaction, lack of oversight, and for that matter, a lack of independence, which we kind of touched on earlier in terms of conflicts or self-dealing, are the things that are increasingly being focused on in breach of fiduciary duty cases. With regard to allegations of lack of independence, those have increasingly focused on whether a director is working for the benefit of all shareholders as opposed to just a particular group of shareholders. Sometimes in some companies it's the case that directors are voted into office. They become directors based on the votes of just a particular group of shareholders. But once they become directors, nonetheless, they are to work for the benefit of all shareholders, not just the group that elected them or the group that they nominally were brought in to represent. Let's talk a little bit more about decision-making as opposed to abdication of responsibilities. The case law, generally from state to state, is pretty consistent in establishing that directors do have a duty to inform themselves prior to making a business decision of all the material information that's reasonably available to them. Directors have a duty to not necessarily be informed of every fact, that's pretty much impossible, but material facts that are reasonably available. The board is expected to act in a deliberate and knowledgeable way in identifying and exploring alternatives. Let me cite one example of a state statute pertinent to directors' responsibilities. That's the Florida Business Corporation Act, but it is largely tracked by similar statutes in other states. That act, for example, authorizes directors to rely on information, opinions, and reports provided by corporate officers and employees and legal counsel, as well as public accountants and other experts, but only so long as the directors reasonably and in good faith believe them to be reliable and competent. You're not excused from acting and using the independent judgment and experience and expertise that got you appointed as a director in the first place simply because officers and other day-to-day managers or experts told you something, if you have reason to believe that their performance is really not what it should be, that they're not reliable in terms of their truthful disclosures to the board, or that they're not even competent. So you certainly don't get a free pass once you're in any way on notice of any particular potential problems. Obtaining reports from management and guidance from outside advisors is, of course, a hallmark of a careful decision-making process. But then again, no board is obligated to heed the counsel of any of its advisors. There's one recent case that found that the directors breached their fiduciary duty by, as I said before, abdicating crucial decision-making authority and essentially yielding that decision-making authority to the outside advisor. In some situations, in fact, courts have recognized that sole reliance on hired experts and management can really taint the board's decision-making process, and the directors therefore must exercise their independent business judgment. That same Florida statute that I mentioned earlier authorizes directors to consider the interests of employees, suppliers, and customers, and the communities in which the company operates when making business decisions. But it is the board that is primarily responsible for the economic performance of the corporation and maximization of shareholder value. And this so-called stakeholder or other constituencies statute, which again is a Florida statute but one that's largely tracked in most other states that I've looked at, is best understood as authorizing other factors to be considered in the decision-making process rather than creating independent corporate obligations on the board. These issues really warrant extra caution, and I guess some of the circumstances, I should say, that do warrant the exercise of additional caution are the potential sale of a company or another type of change of control situation, as well as the selection, evaluation, and compensation of senior executives. I would also add investigation of potential unlawful activity and situations in which the company is experiencing significant financial difficulties. Those are some of the most scrutinized issues and the ones that, of course, are most likely to lead to directors and their decisions being scrutinized either with threatened claims or actual claims of liability for lack of appropriate oversight. One of the questions that we get sometimes, and a good question because it does vary to some extent from state to state, is whether much of what I've been talking about applies not only to directors but to officers. And generally the answer is yes. I mean, obviously, directors, and in particular outside directors at companies that have outside directors, are in a different position from officers who are day-to-day managers of the company. But it is also true that officers in a lot of states are not permitted, just as directors are not permitted, solely to rely on, unquestioningly what's been presented to them by, say, outside experts or employees in certain divisions. Reliance has to be there, and reliance is expected, but I guess the point that I would underscore is that the more serious the issue, the bigger the issue something is for a company, the more that really is required of the top officers and the directors in terms of their analysis of the issues. And though this may be going a bit far, I generally counsel my clients in any situation in which even a legal claim for a significant amount of money is being made against their company, that they really do need to ensure that they're familiar with all aspects of that claim, even though, of course, they're employing counsel, perhaps in-house counsel and outside counsel to work with them. But they have to have some understanding of the merits of the claim. And I even say, make sure before you pay a whole lot of money in a prospective settlement that the money really is owed to the company making the claim. In other words, a company claiming millions of dollars in damages should, on top of everything else, be required, it seems to me, to document that they really have suffered the damages they seek. And I guess my point is it's part of the normal due diligence process, or should be, for top officers and even directors called upon to look at such claims, to ask these kinds of questions and to make sure that you're not overpaying, even if you are inclined to settle and therefore make some sort of payment. Everything that I've talked about with regard to directors' responsibilities is to some extent kind of cushioned by the business judgment rule, but only to some extent. And so let's talk about what the business judgment rule is and how it can protect top officers and directors from claims that they've breached their fiduciary duties. It's important to understand that the business judgment rule is essentially a presumption. It's one that can be overcome, but it is a judicially created presumption that a decision was made by impartial directors who were acting on an informed basis with a good faith belief that the decision would serve the company's best interests. As I said, the presumption can be overcome. What a plaintiff would need to do in order to overcome this presumption that ordinarily protects the directors and top decision makers is a plaintiff would need to show that the director either abdicated decision-making responsibility or acted fraudulently or illegally or oppressively or somehow in bad faith. So the key concepts really in thinking about the business judgment rule and how far it goes are the interestedness or lack of interestedness of the director or top decision maker, relatedly the independence of that decision maker, the good faith, and one thing that is not written on your slide but that I would add is kind of the level of due diligence that was done in making the decision, which will counteract any sense that you simply abdicated your responsibility in making the decision. The stakes are, of course, high for a lot of breach of fiduciary duty claims, at least potentially. The remedies for breach of fiduciary duty are available in the categories both of equitable remedies and legal remedies, and there are a number of things within each of those categories that are potentially available to plaintiffs. The equitable remedies can be pretty serious, of course. They include an accounting, requiring an accounting of what went on, including, obviously, a financial accounting, potentially the imposition of a constructive trust over the company, the disgorgement of profits or commissions for a significant breach of fiduciary duty, and injunctive relief in certain circumstances. Those are the equitable remedies. The legal remedies are in the categories both of compensatory and punitive damages. And what's interesting and somewhat concerning is that at least potentially recovery can be available even when a plaintiff has suffered no damages at all, although what that generally means is that a plaintiff who has the right to sue on the behalf of a corporation, such as in a shareholder derivative suit, doesn't need to demonstrate that the plaintiff individually has suffered damage, merely that the company has suffered damage as a consequence of what was done by the top decision makers. So that's kind of an overview of fiduciary duties, their extent, and their limits. Let's talk about external auditor duties, that source of duties and source of potential liability, focusing on what clients, namely the company, what kind of rights they might have against external auditors for less than optimal performance of the auditor's work. Auditor liability does lead to a lot of litigation, and kind of the genesis for most of that litigation is the notion that an auditor does have a responsibility to provide reasonable assurances that a reporting entity's financial statements are free of material misstatements. And that means material misstatements that were simply erroneous, as well as material misstatements that were fraudulent. So we'll talk a little bit later about how an auditor, in this instance this is a good thing for a company wanting to sue an auditor can't really say, well, I was defrauded by the company. It can say it, but it's only going to have a marginal level of success and viability generally, because an auditor really does have a duty to detect the fraud if there is one. An auditor or audit firm that fails to detect a material misstatement in a client's financial statements will oftentimes end up in the position of having to defend against accountant's liability for negligence, or the stakes can be even higher because there can be some sort of claim of intentional wrongdoing or poor performance that was born of such recklessness that potentially very significant damages can be racked up. Claiming reliance, as I said before, upon fraudulent or misleading information provided by the management of a company in a management representation letter generally is not a viable defense against auditor liability, even when that assertion is actually true. So even when an auditor can say that I was deceived by the client representatives, the company representatives I was dealing with, even when that's actually true, it's not going to be all that helpful. It's not going to make the company look very good if it can be demonstrated that company representatives did indeed mislead the auditors, but that uncomfortable fact isn't going to stop the company from being able to prevail on a claim potentially against the auditor or threaten the auditor with a claim that might lead to a productive settlement. Auditors really have, just like directors and top managers within the company, they have the potential to be legally liable for all sorts of failures. And generally speaking, the categories of types of failures that can lead to their most significant legal liability are as basic as just failing to understand the client's business, because I think we can all expect that it would be the case that an auditor isn't going to do a very good job if the auditor never takes the time to really understand the nature of the client's business and grasp certain nuances that are important to understanding its finances and its outlook. So understanding the client's business is a basis for auditor liability, failing to do so, failing to perform quality audits, failing to properly document the work that the auditors do, and of course failing to maintain confidentiality. So each of those broad categories can give rise to potentially very serious legal liability for auditors. A couple of the concepts that you hear about in the world of auditor liability, accountant liability, are audit failure and audit risk. Audit failure generally describes when the auditor issues an erroneous audit opinion as a result of an underlying failure to comply with the requirements that are applicable to the auditor, which is generally accepted auditing standards, also known as GAAS. Audit risk describes the risk that the auditor will conclude that the financial statements are fairly stated and an unqualified opinion can be issued when, in fact, they really were materially misstated. There are all sorts of sources of liability under the common law, case law, for auditors. And, of course, we're talking about auditor liability to clients, although they can be liable to third parties as well. Auditor liability to clients can be as simple as a breach of contract action, or it could be under tort law. Tort, of course, meaning a wrongful act that's not part of a breach of contract, a wrongful act that injures another person's property or reputation. And under tort law, the bases for potential liability are a range of things from ordinary negligence to fraud, and let's go through some of them. Ordinary negligence is the failure to exercise the care that a reasonable person would exercise under the same circumstances. Gross negligence is the failure to use even slight care in circumstances that require extreme care, or at least significant care. And fraud, of course, is intentional deception. Now, in addition to those sources, that is contract law and tort law, you also have certain statutes, things other than case law, common law. You've got statutes in a number of states that talk about deceptive trade practices, and while that varies from state to state and is really kind of beyond the scope of this webinar, just know that companies should be aware of what rights they might have against audit firms. Audit firms, of course, need to be aware of what rights others might have against them under particular statutes, including most principally deceptive trade practice statutes from state to state, some of which are very broadly worded. What are the types of defenses that an auditor is likely to bring up in the course of defending against claims by a client? Again, we've got four primary categories of defenses. One is the lack of any duty to perform, and generally that's going to be a contract-based defense, that there were certain disclaimers, for example, in your broadly worded contract with the auditor, which is, of course, often an auditor form contract, and the auditors, of course, in their forms generally talk about all sorts of exclusions to their liability, all sorts of things for which they're not going to be responsible. And so in the negotiation process, in the drafting process, it is important for companies, in order to retain and reserve rights to go after auditors, to scrutinize exactly what's being excluded and fight for a real restriction on those exclusions. That is, fight for more things to be covered, understanding that these auditors really badly want the work generally from the companies, want to be able to do the work, and are, at least in my experience, generally willing to negotiate at least somewhat with respect to what the scope of their duties are. Another big category of defenses for auditors against clients is simply that the performance wasn't negligent. That they did have a duty, they acknowledged that, but they really didn't do anything wrong. And so that's going to get very fact-intensive, but generally speaking, at least in my experience on the plaintiff side with these kinds of cases on behalf of major companies, where there's smoke, there's fire, and there is some real opportunity to point out that things that were important were not done properly. And we've been able to do that with success in such suits. Contributory negligence is another type of defense that one comes across often in these kinds of cases. But as I mentioned before, saying that the company contributed to the problem generally is only going to get the audit firm so far. It kind of besmirch the reputation of the company, make the company a little uncomfortable that the company did things improperly or may even have misled the auditor. But while it's a viable defense and one that I can't say never works, it's one that's generally not as fruitful for audit firms. And finally, the absence of a causal connection. I mean, this really cuts across litigation generally. It doesn't just have to do with audit suits, but what audit firms can do, often with some real success, is to demonstrate that whatever mistakes they may have made, they weren't the ones that caused the company's damages of which the company is complaining, that all sorts of intervening factors or pre-existing issues are the ones that have led to the company being in a place where it doesn't want to be. That's really the overview of key issues for both fiduciary duties and auditor liability and potential claims against auditors. I would encourage you, if you have questions, to get in touch with me. I've listed my phone number here on the last page of the presentation materials. We've also listed some other means by which you can contact us, and would be happy to be of further assistance with these issues. Thank you very much.
And that is all the time we have today. Phil will take your questions via email. We value your feedback. Please take a moment to respond to the 5-question survey before exiting today's webcast. Ladies and gentlemen, this does conclude today's conference, and thank you for participating in the Bilzing-Sumberg Homebuilder Series webinar, Fiduciary Duties and Auditor Liability webcast.